Be seated, please. I guess I can move this back a little. Our next case on the docket is In Re Office of the Attorney General of the State of Texas. Mr. Stone, you may proceed.
Thank you, Your Honor. May it please the Court, this case represents a direct attack on the Attorney General's constitutional, statutory, and common law authority to conduct investigations into corporate entities in the state of Texas to determine if they are exercising powers not authorized by law. The question before the Court today is, did the trial court abuse its discretion in denying the Attorney General's Rule 202 petition, where the Attorney General has the authority to take pre-suit depositions as a matter of law, and where the competent evidence showed that the benefit of taking a pre-suit deposition greatly outweighed the procedural burden on CCRGV? This Court should find that the trial court did abuse its discretion. First, the Attorney General has the authority to conduct pre-suit depositions of corporations as a matter of law. The Texas Constitution states that the Attorney General shall especially inquire into the charter rights of all private corporations and from time to time initiate court proceedings to prevent them from exercising any power that is not authorized by law. That is codified in the Texas Business Organizations Code, which authorizes the Attorney General's office to conduct investigations and to examine the records of corporate entities. If it determines that they are engaged in conduct or exercising any power that is not authorized by law, the Texas Government Code and the Civil Practice and Remedies Code authorizes the Attorney General to initiate quo warranto proceedings to revoke the charter of those corporations. In Humble Oil, the court held that the Attorney General has an unlimited and unrestricted right of visitation as to the visitation powers that it has. The same is true of its investigative powers. This court should find that investigations necessarily include depositions. They can include lots of other things too, but they also include depositions.
I'm sorry.
If that's true, I know the Attorney General seeks documents from corporations all the time under the investigation statutes and doesn't have to file a lawsuit to do it, usually. If that's true that as a matter of law, those same statutes give you the power to take a deposition, then why do you need Rule 202 as a proceeding?
We have it's belts and suspenders as the idiom goes, where we've got a variety of tools. So we can request deposition upon written question, we can take examinations under oath, we can send subpoenas, and we can deploy Rule 202. In this case, we chose to use Rule 202 as the procedural mechanism to take the pre-suit deposition. But there are a variety of other tools that we could have used, did indeed attempt to use in this case to obtain a pre-suit deposition. If you look at Exhibit 1 and the mandamus record, we opened with a request for them to appear for an examination under oath, which is similar to a pre-suit deposition.
But what? Go ahead.
So take those one at a time. The alleged common law right or arising implication from the Business Organizations Code. How long has investigate been in the statute?
The word investigate has been in the statute since its inception in 1907, I believe.
Right. So according to Professor Dorsanio's article on the Texas Rules of Civil Procedure, oral depositions as we know them, deposition meant something different in 1907 than it did now, because all you could do was discovery related to the other side's pleadings. And he says in this lead law review article, which I'll give you the citation for, that in the old statutes, when they said deposition, what they meant was a deposition on written questions, which is basically you sent somebody written questions, they conferred with their lawyer, they showed up in front of a stenographer, and they read out their answers. It wasn't until the scope of discovery was expanded in the 1940s, the options of the Rules of Civil Procedure, and wasn't expanded in practice till the 60s, when it was relevant not just what was pled, but what might lead to admissible evidence. And so he argues that oral depositions did not mean what you and I think of as an oral deposition until long after investigate was demanded. Now, assuming he's correct, and I don't know, I'll give you some time to look into that and respond if he wasn't, but I recall several Supreme Court cases that appear to, what, in the 1800s, that appear to support that, then we have to apply what depositions meant and what investigation meant. Investigation may have included depositions back in 1907, but not like we're talking about today.
Your Honor,
It's a lot, I know.
this wasn't a topic that we briefed, but my initial reaction to that is I would like to point out to the court that this particular statute in the Business Organizations Code has been recodified multiple times, 3 times, I believe. Most recently, I believe, in the 1960s. So the legislature, when it adopted the most recent version of this law, would have been aware that investigations could have included oral depositions, and that depositions at that time could include not only depositions upon written question, but also oral depositions.
It's, by the way, it's Baylor Law Review, Volume 65.
Thank you, Your Honor.
Just, yeah, take a look at that after argument. I'd hate to spring that on you, but it's, I didn't know that. None of us were around in 1907. I doubt if you would have knowledge of it either, but let me know on that, because I am troubled by that. And why has the question never arisen till now about this common law power to take oral deposition?
Well, it just hasn't been challenged, Your Honor, before. The Attorney General's Office has deployed a variety of investigative tools in the past. This is just the first time, to my knowledge, that the Attorney General's Office has attempted to use Rule 202 to obtain a deposition in this kind of context, and where it's been challenged and has come up before a court of appeals.
Once you invoke Rule 202, though, don't you come under the case law that defines the trial court's discretion and the benefit, weighing benefit and burden, which seems very discretionary? But you say it's as a matter of law. Are you saying the trial court has no discretion if the AG says we want a corporation's deposition?
Because we decided to use Rule 202 as the procedural mechanism in this case, the court does have discretion. But what our argument is that the Attorney General's Office, the constitutional, statutory, and common law powers of the Attorney General to conduct investigations of corporations acts as an anvil on that scale as it's conducting the balancing test.
Can you walk us through that balance and how it plays out here?
Yes, Your Honor. So in this case, the balance that is conducted under Rule 202, where you first, to tee that up, the Attorney General's Office has to show that what is the subject that it seeks to investigate with the Rule 202 petition and its interest therein. We've satisfied that in our Rule 202 petition, as you can see from the record, by identifying what we're specifically looking at with the corporation and our authority to look into CCRGV in this case, and its basis, which we've talked about already, the Constitution, the Business Organizations Code, and the common law. The balance itself is, in Rule 202, is looking at whether the likely benefit to the Attorney General's Office is greater than the procedural burden on CCRGV. In this case, and there is a scenario where, despite having significant powers to conduct investigations of entities like CCRGV, where the burden still might be appropriate, where the Attorney General's Office could lose. For example, a time, place, manner. If we noticed, we sought in our petition, our Rule 202 petition, to depose CCRGV in Alaska at midnight tomorrow, and we gave them 350 topics that were broad, that might weigh against granting that Rule 202 petition, despite having our powers to investigate corporations. So, but that's not the case here. We have 4 discrete topics, and in the Rule 202 petition, we said that we were willing to work with CCRGV to find an appropriate time, place, and manner to conduct the deposition. Now,
what is the necessity, though, of doing this all pre-suit?
Yes, Your Honor. So the only way to do it post-suit is if we brought a quo warranto proceeding seeking to revoke their charter. The purpose of the Rule 202 deposition is to conduct investigations into potential claims. So Rule 202 gives us the ability to look into and determine whether or not there are grounds to bring a quo warranto lawsuit in the future. Here we have exhibits 1 through 11 that show over a 3-month period we went back and forth with CCRGV, asking for documents, asking them to provide, to come and sit for an examination under oath. We sent them questions and they returned a sworn statement, which we found to be evasive. We made multiple efforts over a 3-month period to try to obtain information. And what they did is they did these little breadcrumbs where they trickled it along and they gave us little pieces of information and dragged it out. And ultimately, the Attorney General's office concluded that the most efficient way to get the information that we need for our investigation is to just come sit for a pre-suit deposition, not trickle things out over the course of months or a year. We just want them to come and sit and answer questions. That's particularly useful in this context because CCRGV, as we learned from Exhibits 1 through 11 in the mandamus record, doesn't have written policies for much of the information that the Attorney General seeks about how they intake certain migrants into their facilities, how they interact with law enforcement. There's a lot of information that we want to obtain from CCRGV that we can only obtain from a pre-suit deposition.
And what violations of state law do you think they may be committing?
They could potentially, depending on what we learn, potentially be violating the Penal Code Section 20.05A1. That makes it unlawful to use a means of conveyance to transport an individual.
So you think they're using motor vehicles or aircraft or watercraft to move people? Seems like you could get a video of that.
That would be one of the investigative tools that we are authorized to use. Again, pre-suit depositions are another tool. We also, and that is that's one potential provision that they could be violating. We do have reason to believe that they are transporting migrants using vehicles, by the way, to Anzalduas Park. But we'll learn more information about that once we take the pre-suit deposition.
But isn't the problem here, though, that what I'm hearing is the Attorney General says they're being evasive, but then it goes to the trial court who has a discretion to weigh the evidence, and he or she, the district judge, may decide they're not being evasive, they're actually answering your questions. So how do we decide, you know what, AG, you're correct, they're evasive, therefore, as a matter of law, you had to get the 202 deposition, when the Supreme Court has told us that a trial court has discretion to weigh the evidence?
The evidence that the trial court should be weighing is whether or not the likely benefit exceeds the procedural burden. And I want to emphasize procedural burden. That's time, manner, place. That's what the balance is here. Again, the trial court could look at and determine whether or not the CCRG is being evasive, but that's sort of beside the point. The bigger issue is what is the likely benefit of a pre-suit deposition? And here we've shown through Exhibits 1 through 11 that there is a likely benefit to the Attorney General's office because most of their policies and procedures are not written. So the only way that we're going to get them is if we have them come in and sit down and we can take a pre-suit deposition. If we can't do that, then organizations could simply avoid regulation by the Attorney General's office writ large if they just never write anything down. We'd have no ability to conduct examinations of them because we can never bring them in to actually sit for a pre-suit deposition.
So what are the limits of this? The Supreme Court said in 2008, 202 depositions have never been intended for routine use. They're practical as well as due process problems with demanding discovery from someone before telling them what the issues are. What possible limits are? It just sound like you said, well, you certainly argue violation of state law is a benefit to the state, and so anytime the Attorney General thinks somebody's violating the state law, you have a right to take a deposition, pre-suit deposition.
Two things in response. One, the fact that this has not come up before the court before shows that this is not a tool that we regularly use during the course of investigations. I think
Not yet.
But didn't you also say there's an anvil on the scale
Our contention,
in your favor?
Our contention is that there is an anvil on this scale. So if we do use this tool and continue to use this tool in the future, we think that it operates, again, as an anvil on the scale. But there are limits, and I talked about them, the time, place, manner. That's the limitation, that procedural burden on the respondent in the case. That is the limit.
But the fact is you get to take it in any case you want.
Yes. The only limitation being the procedural burden. That is the limitation, not setting it, again, in the middle of the night or some...
Right.
Crazy criteria.
And there are a bunch of these, but there are a bunch of these almost exact cases pending in the appellate courts right now, right?
There are other cases that involve a request to examine records and other tools, investigative tools that have been used by the Attorney General's office when looking at private corporations in the state of Texas. But there are no other cases that I'm aware of involving Rule 202 and that specific procedural mechanism that are before the courts of appeals in any federal or state court. For all the foregoing reasons, we'd ask that this court reverse the trial court's ruling and direct it to enter judgment in favor of the Attorney General's office on its Rule 202 petition. Thank you.
Thank you, Mr.
Thank you.
Stone. Mr. Powell.
Good morning, Mr. Chief Justice, and may it please the court. Rule 202 depositions are disfavored. As you mentioned, the Supreme Court of Texas has explained they are not for routine use. They raise due process concerns, and if abused, they could become a license for forced interrogations. To ensure that Rule 202 applies only in appropriate cases, the text of the rule itself requires that a party seeking a pre-suit deposition to investigate a potential claim, as the Attorney General says he is doing here, must present evidence proving that the likely benefit outweighs the burden or expense. The Attorney General did not meet that demanding standard here. He presented no evidence whatsoever to the district court suggesting that there's any basis for his investigation or that there would be any benefit to a deposition. At the very least,
Go ahead.
The
The same Dorsanio article I mentioned seems to treat the oral deposition on answers to written interrogatories from 100 or more years ago, more than a century ago. That's when somebody was about to die or going to move out of state or something like that, and it was limited to circumstances where somebody wasn't going to be around for trial. And is there any limit like that? The rule doesn't say that anymore, it's limited to people that are not going to be available at trial. And we wiped that out from oral depositions generally, even if you can do pre-suit depositions. I mean, you can do post-filing depositions anytime you want. But is there haven't we done the same thing with 202 depositions? It's not limited to people that are about to die or anything like that.
So there are two different prongs in the text of Rule 202. And Mr. Chief Justice, the 202.1 lists the two different reasons that you can take a pre-suit deposition under Rule 202, and I think A is the one that you might be referring to, which is to perpetuate or obtain a person's own testimony or that of any other person for use in an anticipated suit. And then there's a different showing that you have to make to get that kind of a pre-suit deposition. The Attorney General has not sought that type of a pre-suit deposition. The kind they are looking for here is under 202.1b, which is for investigating a potential claim. And that's where you have to do the benefit versus burden analysis. And the Attorney General said,
Considering many factors and a balance and all the things that are wrong with balancing tests.
it is a balancing test that is in the rule, and so it is one that the district court has to conduct. But I think surely mandamus relief is not appropriate here, where there was almost no evidence in the record, and the district court made that fact-bound determination to balance the burden and the benefit and came out where he did. So I think the only thing really that the Attorney General can say is, I didn't have to present any evidence because I automatically win because I'm the Attorney General. No court has ever held that the Attorney General satisfies Rule 202 as a matter of law. There's no support for that in precedent, no support for it in the text of Rule 202, and no support for it in the text of the Business Organizations Code.
But apropos my argument about running a railroad in the previous argument, this issue is fraught with political differences. And it may be that the judges in a particular locality are for or against people seeking asylum in this country. And how do we ensure that that doesn't end up putting an anvil on this side of the scale or that side of the scale? And so that we have the same rule in the Valley that we have in El Paso and everywhere in between and Texarkana.
Sure, Your Honor. So I again want to separate the two arguments that they're making, because the anvil argument that's on their side is a purely legal argument, and I think you can consider that just as a matter of law. As for your review of the balancing of benefits and burdens, which is what I take you to be asking
Yes.
about, what if courts are too skeptical of the benefits because they're too supportive of immigrants or something like that? I think, or vice versa.
Right.
I think there you have the mandamus standard, and if there is a clear abuse of discretion based on the evidentiary record, then of course you can issue mandamus and require the court to reach a different decision. But here, again, this was an evidentiary hearing, and they came to the evidentiary hearing without any evidence other than documents that we ourselves produced that show that we comply with the law, that we only take non-citizens at our humanitarian respite center who have been processed by the federal government, who have been given paperwork, and who are in the country lawfully. There was also a sworn statement by Sister Norma Pimentel, the executive director of CCRGV, in which she swore under oath that they only take immigrants who have been processed by Customs and Border Patrol and who have proper documentation. I don't understand how they could think that a deposition of Sister Norma is going to produce anything different than what she already swore under oath.
Maybe they
to
have
the
some
case.
Perry Masons that cause the cross-examine. Okay, you're right, I did the murder. Maybe they're such good cross-examination. What's the risk if Sister Norma is unlikely to break down under cross-examination?
Well, I think there are three relevant burdens, Your Honor, that I would emphasize here that were in the benefits versus burden calculus. The first burden I would mention is the scope, which is, I think, the one that courts most often look to and that my friend highlighted. It is true that they mentioned 4 topics, but those 4 topics are really quite broad. And if you look at other cases where the burden was found to be low, like the Dallas case that they cite, there the burden was really only, or the limited topics were really only about one element, say, of a claim. Whereas here, the 4 topics cover basically every possible aspect of the operation of the Humanitarian Respite Center. Just one of those 4 topics was CCRGV services provided to aliens as part of their humanitarian crisis response program, including, but not limited to, services provided through its Humanitarian Respite Center. So that's really quite broad. It's a lot of topics. So that would be the first burden, I think, that's relevant here.
Do
The
they
second
have to
burden-
show a violation of the law to get a 202 deposition?
No, Your Honor. For purposes of a 202 deposition, we agree with the Attorney General that they don't have to show all the elements of a claim, which I'm not sure if that actually answers your question. So maybe let me take it in 2 parts. They don't have to show all the elements of a claim for purposes of getting a 202 deposition. So whatever civil claim that they're trying to pursue, I think they have to show at least enough evidentiary basis for that type of claim that you could understand, oh, if we order a deposition, they might be able to find something here. And I would point you to a couple of points of reference for that. The first would be cases, including ones that my friend cited in his brief, where courts have found a sufficient benefit. One of those is the In re Tatum case. In that case, a woman was sexually assaulted by a police officer who was responding to an ambulance call. She had a lot of facts that were relevant to the claim that she was likely to bring, to the potential claim. She understood the wrong that had been committed and basically who had done it. And what she needed to do was just to understand a little more about the police department's policies so that she could understand whether she might have a 1983 claim in federal court. I would also point to the drilling contractors case. That was one from the First Court of Appeals. There, a defamatory safety alert was posted online about this company's operations. They knew that the defamatory alert was out there and sort of what their claim was going to be, a claim for defamation. What they didn't know was who had reported the safety alert to the reporting agency, and so they just needed that small sliver of their claim to be filled in. That's the kind of thing that is a benefit for Rule 202. It is not just a pure fishing expedition where we don't know, we're hypothesizing that there might be a problem. I would also point, as a point of comparison, Your Honor, to both the Annunciation House case that is pending before the Supreme Court of Texas and the Fiel case in which this court heard oral argument a few weeks ago. I think what we've seen is perhaps some overreach across the board to go straight to quo warranto in those cases. But I think for purposes of 202, the kind of evidence that the Attorney General put forward in those cases, where they had, in the Annunciation House case, it was statements from the director of Annunciation House talking about serving non-citizens who were undocumented. In the Fiel case, I think there were like flyers and social media posts that they claimed violated the tax laws. And so there were at least some specific evidence to support the claim, but there's nothing like that here.
So that of course, is the alternative. They could have just filed a quo warranto action to revoke your charter and then do the discovery afterwards. How is this worse than that?
This is not worse than that, but that would be very, very bad, and this is very bad. This is just a little less bad.
But it seems like they're
Let
saying.
me write
if
that
they-
down.
It seems like they're saying if, this is the alternative, that things will get very, very bad if we don't have this particular tool.
So I don't think that's right, Justice Ferris. I think, as he said, they have many tools in their toolbox short of Rule 202. Here, they chose to bring a 202 petition,
Sure.
so I think they have to comply with Rule 202. But they could have, we agree that under the Business Organizations Code, they can get records. And I take him to be making a sort of slippery slope argument that people aren't going to keep records. We have a lot of records. And actually, we created some records to try to take our oral policies, put them in writing so that we could explain what those policies were to try to be very forthcoming with this investigation. So we're not trying to be evasive whatsoever. And I think they also, they have investigators. They can pound the pavement. They can talk to people, get some kind of leads, do the sort of police work that any kind of organization would do. And then once they have a factual predicate for their investigation, then by all means, come get a 202 deposition. But they have to have at least a little bit of a factual predicate to start, and that's what they didn't have here. If I could return quickly to the burdens, because I think I got through 1 out of 3. The other two, and I think maybe this goes a little bit to your point as well, Justice Field, is that although it is with an eye toward a civil quo warranto proceeding, the violations that they're alleging here are criminal violations. And those are pretty serious allegations against a nonprofit organization. And I think it makes the deposition quite a bit more burdensome that we're going to have to prepare for potentially Fifth Amendment issues that might come up. Of course, we could address that on a question-by-question basis. I'm not arguing that. But just that is going to make it a more burdensome deposition. And certainly Rule 202 is a civil rule. It is not supposed to be, generally speaking, for investigating crimes.
Well, you anticipate a little bit of the question I already had for Mr. Stone on rebuttal, so I'll give him a head start, which is, if we have Sister the nun, I assume, under oath saying, we didn't do this, and then you depose her, and you're trying to establish, yes, you did, and that's criminal, why could the trial judge look at that and say, so basically we're going to have a deposition of invoking the Fifth Amendment over and over and over again, and what is the benefit of doing that?
And I would mention, Your Honor, that actually that did come up in the hearing transcript if you take a look at it, and the judge did say that he had a concern about the potential Fifth Amendment ramifications here of this deposition, so I think that's totally a fair concern. The third burden that I would mention on the burden side of the scale is that this is a religious organization. Just as they don't have to plead all of the elements at this point yet, we don't have to raise Texas RFRA as an affirmative defense at this stage because it's just a pre-suit deposition. But I still think that the kind of religious burdens that could be put on Sister Norma or whoever gives the deposition by this deposition are cognizable under Texas law, or things that you should take into account in doing the benefit and burden balancing under Rule 202. And in particular, I think some of these topics that they've outlined that are about how they operate the Humanitarian Respite Center could go to things like their association with other religious organizations, the way that they interact with the diocese. They've mentioned Catholic Charities USA in some of their paperwork, which is actually a separate organization. And so it could pry into some sensitive, to some extent at least, religious associations. The last thing I would also say about how the test applies is that not only do you have to have the benefit and burden balancing, but you do have to have a potential claim. And I think this goes to your point as well from earlier, Justice Field. There is, I think, some lack of clarity in the law at the moment what their potential claim under quo warranto might be. The Texas Supreme Court may weigh in on that in the Annunciation House case. This court may weigh in on that in the Fiel case. And I don't want to get out too far ahead of those. But I think there is at least a plausible argument that in order to bring a quo warranto action based on a criminal violation, there has to first be charges and a conviction. And of course, there's been nothing like that here. And insofar as that is the correct reading of the law, which I think Annunciation House has argued in their papers, then there would be no potential claim here, and that would be another reason that the Rule 202 proceeding should fail. I also wanted to mention, I think my friend suggested there might not be any other Rule 202s. This was one of a kind, but there is a Team Brownsville Rule 202 petition as well, and I believe that is now pending before this court as well. I don't have the case number right in front of me, I apologize, but that is at least a second Rule 202 case that is pending before this court. The other thing I wanted to mention is, sorry, I lost my place in my notes, basically, with respect to the visitorial statute, I'd like to make two other points about it because we haven't talked about it too much, the as a matter of law argument. First, I think it just doesn't really matter, to Justice Field's point from earlier, because he has come to court here under Rule 202. And so to use Rule 202, he has to meet the same standard under Rule 202 as anybody else, no matter what authorities he may or may not have under the visitorial statute. The other thing I would say is that there are serious constitutional questions about the visitorial statute. A federal court has now declared that statute facially unconstitutional. That's been appealed to the Fifth Circuit. But of course, insofar as that statute is unconstitutional, to your point, Chief Justice Brister, about the how to run a railroad and who's in charge, if that is declared unconstitutional, then of course they cannot rely on it here. I would also say, just as a matter of text, I don't think that the text of the visitorial statute, even separately, provides power to take depositions for the sort of textual reasons that we explained in our brief. And with that, I think I've made the points I'd like to make. If there are further questions, I'm happy to address them, but otherwise I'll sit down. Thank you.
You're very efficient, Mr. Powell. Thank you.
Appreciate it.
Mr. Stone?
Before you get going, I know you've got a lot to cover. Could you address the point about the relatively thin evidentiary record here?
Yes, Your Honor. We don't agree that it's relatively thin. We are only required to, so set aside the Anvil argument, set aside all of that. Like, let's just do the balancing with the evidence that was presented. They presented no evidence during the evidentiary proceedings, none. There's no exhibits from CCRGV. They presented no evidence as to the procedural burden on them. So at most, it is de minimis on the scale, the balancing scale for them. On our side, we presented 14 exhibits, of which 13 were admitted. The exhibits 1 through 11 show the attempts over a 3-month period to try to obtain information and how it was unsuccessful from CCRGV. It was unsuccessful for several reasons. One, because we were seeking written records from them and they don't have written records for a lot of the information that we seek. Then we sent them questions and they agreed to provide us with a sworn statement in response. That sworn statement in response we determined to be evasive. I'll give you a concrete example from that. We asked them to identify the CCRGV folks who talked to CBP and ICE officials. Their response says, and you can see it in the record, I believe this is Exhibit 11, the response is CCRGV representatives contact and communicate CBP and ICE officials. Well, we asked them to identify the actual individuals, and the response was CCRGV folks do talk to CBP and ICE. It's one example of the evasive responses we got from them. So we determined that the likely benefit here, and we believe that the trial court got it wrong, the likely benefit of a pre-suit deposition exceeds the procedural burden, because in this case, we can keep doing this little trickle where we're trying to figure out what exactly the right question is where you don't have any documents, right? And each answer we get to a question's 1 or 2 sentences long, or we can just bring you in and sit down and just resolve this in one setting with a pre-suit deposition. Which leads me to the next topic. My friend on the other side mentioned that the topics are so broad that it would be very burdensome and difficult for them to respond to. Well, I'd like to quickly go through at least a couple of them. The first one is the 4 topics. The first one is CCRGV services provided to aliens as part of their humanitarian crisis response program. Unless they provide unlimited services, that should be a narrow topic that lists just the services that they provide. That's not an unlimited topic. And more importantly, the 4th topic is CCRGV's practices for facilitating alien crossings over the Texas-Mexico border. So if that's a very broad topic and there's a lot to talk about, that's certainly a topic that we'd like to get into with them. That's a red flag for us when they indicate that that's a very broad topic that they would have a lot to say about, and that the scope is very broad for them. If the answer is anything other than none, we have a lot of follow-up questions that we want to talk about with them on that topic, which goes to the 5th Amendment question that was brought up. The 5th Amendment was brought up during the trial court proceedings, and our friends on the other side said that they had not raised it to that point. They didn't anticipate raising it, but if it did come up, they would raise it on a question-by-question basis. The 5th Amendment isn't a writ large to just never take a pre-suit deposition. If it were to come up, they could raise it on a case-by-case basis, and then it would be for a court to determine whether or not to permit that privilege to be invoked.
Let me ask you, how is what you're proposing to do, either under the common law investigation or the Business Organizations Code, Is it the same as or different from a civil investigative demand?
It's different. It's similar, but it's different. It's one of the many tools. So what we're attempting to do here, so a civil investigative demand, we could ask for records. We can ask them to produce different things. We often use a civil investigative demand or a CID in Deceptive Trade Practices Act
And
investigations.
they generally authorize you to examine under oath any person.
Correct.
We don't have that in this case.
In this case, the way that the Business Organizations Code is written, it's much broader. It just says investigate. And we interpret that broadly. We have the full plethora of investigative tools that the Attorney General's office deploys. They're all available because the statute doesn't say you can investigate and only investigate using this particular tool, or only investigate using that particular tool.
And again, about doing brand new things, has this ever been, any case, ever addressed this issue before?
In Humble Oil, the court did look at this statute, and it said that the Attorney General's authority was unlimited and unrestricted as it related to requesting records under the Business Organization Code.
Set aside records. I don't think they're contesting records, and records is pretty clear, but whether investigates enough to get an oral deposition, any case, this would be the first case that ever says one way or the other on that.
Your Honor, I see that I'm out of time. May I answer?
Please answer.
Yes, this would be the first of its kind, but we believe, even again, setting aside the Anvil and entitlement as a matter of right, that based on the Rule 202, the competent evidence introduced during the Rule 202 petition proceedings, the Attorney General's office demonstrated that the likely benefit to the Attorney General's office exceeds the procedural burden on CCRGV. Therefore, the trial court's ruling was an abuse of its discretion, and we ask you to reverse and remand with instructions to enter judgment in favor of the Attorney General's office on its Rule 202 petition. Thank you.
Thank you, gentlemen. Anything further? We'll take again a brief adjournment, a brief break until we return for the final case. Thank you.
All rise.